Good morning. My name is Stacy Blank. I'm here today on behalf of the appellant, Villa Bellini Ristorante Lounge. I would like to reserve 5 minutes of my time for rebuttal, please. This case is simple and straightforward. The appellee, Mr. Mancini, filed a petition for writ of mandamus in the trial court to enforce his right as a purported shareholder of Villa Bellini to inspect the corporation's records. Section 607, 1602 of the Florida statutes entitles shareholders to inspect and copy certain records of a corporation. Non-shareholders, however, do not have a similar right. In this case, Villa Bellini disputed Mr. Mancini's status as a shareholder excuse me, and produced sworn evidence in support. Under Florida law, a petition for writ of mandamus must be denied when the petitioner's entitlement to the right he seeks to enforce requires the resolution of disputed questions of fact.
You've cited a considerable body of law that cites that proposition. It raises in my mind, though, almost begs the question, what then is the point of the alternative writ proceeding, where you can have an evidentiary hearing given that body of law? Or do we just have this situation where we've got two kind of competing veins that have really never been synthesized?
So I think the way that those cases can be reconciled is to look at what is the focus of the fact dispute. If the fact dispute goes to the petitioner's right to relief, the mandamus petition has to be denied. If the fact dispute goes to, for example, as in the Radford case, the ability of the respondent to comply, that can be decided. I mean, that I think is the way, and it makes some sense to me because the alternative writ should only be issued if there is a clear legal right. I mean, mandamus is designed to enforce a clear legal right to relief. It's not designed to adjudicate the petitioner's entitlement to that right. And so if that is what is at issue, and there are disputed issues of fact about that fundamental right to relief, then the mandamus petition has to be denied. If the fact dispute involves something else, I don't have the documents, for example, then I think the court can proceed to have an evidentiary hearing with respect to that.
Okay. I'm trying to figure out how you would articulate that distinction. I mean, you've distinguished the case where you got the clerk and the court reporter saying, we don't have the records, we don't have the records. And the alternative writ would be an appropriate proceeding in that instance. I'm just wondering how you generalize the distinction that you're trying to draw here.
I think the way that I arrived at this distinction is to look at the language that the cases use that require the mandamus petition to be denied. And those cases very carefully say when the fact dispute relates to the petitioner's entitlement to the right to relief. So I think those cases themselves are narrowing when the mandamus petition has to be denied. But that's what we have in this case. Here we have a fact dispute that centers on Mr. Mancini's right to the relief that he seeks.
So are you saying then an evidentiary hearing shouldn't even been had?
Correct. I think if you'll look at the Emmer case, the Blatt case, those cases say that the moment there is a fact dispute with respect to the petitioner's entitlement to the relief, mandamus has to be denied. Now, the petitioner could assert some other cause of action, could seek a declaratory judgment, for example, or file a direct action under the statutes.
And so there was an objection made by your client to the evidentiary hearing?
Correct, there was. And there was a request that the petition be denied for that reason. And it makes sense if you look at the way that the mandamus proceeding is supposed to work. And that's why this case got so upside down. Rule 1.630, Florida Rules of Civil Procedure, provides that if the allegations of the mandamus petition establish a prima facie basis for relief, then the alternative writ or the show cause order is to issue. Once the alternative writ or the show cause order issues, then the respondent is required to come forward with respect to the facts underlying its failure to perform. If that response establishes that there is a disputed issue of fact about the petitioner's entitlement, then the mandamus petition should be denied. But the Florida Supreme Court has differentiated very clearly the difference between a burden of ultimate proof and the burden of production. And that's where we got off the rails here, I think. Because the court, by using the mandamus proceeding to resolve the disputed issue of fact about whether Mr. Mancini is a Villa Bellini shareholder, shifted the burden of proof onto Villa Bellini to disprove Mr. Mancini's status as a shareholder. In any other civil proceeding, the burden of proof would have been on Mr. Mancini to establish his status as a Villa Bellini shareholder. But here, because the court used the mandamus procedure and overlaid that on the resolution of the disputed issue of fact, it in fact required Villa Bellini to disprove Mr. Mancini's case. Over Villa Bellini's objection, the trial court required Villa Bellini to put on its case first and to proceed in all respects as the plaintiff. The trial court then ruled against Villa Bellini and in favor of Mr. Mancini at the close of Villa Bellini's case without ever requiring Mr. Mancini to put on a single witness. It was essentially some hybrid directed verdict sort of standard to say, you haven't demonstrated good cause why he's not a shareholder.
I'm curious though, how, given that your client was able to put on its case, I think if I understand the harm that you're saying that this visited upon your client is that the trial court imposed the wrong burden of proof.
I think that's right. It shifted the burden
It's
of
not that
proof.
it's not that they were precluded from presenting anything that they wanted to present or proffer any evidence. It's just that the trial court utilized the wrong burden of proof.
Well, I think that's right. It shifted the burden of proof to Villa Bellini rather than the plaintiff in the case.
And where do we see that within what we've got before us? How do we know that that's what the trial court did?
So I think you can see both in the trial transcript where there's a discussion at the beginning about who has the burden of proof, and the trial court says very clearly that I think the burden of proof is on Villa Bellini and you need to go forward. And then you can see in the trial court's final judgment, it says that Villa Bellini failed to meet its burden of showing good cause why the petition should not be, or the writ should not be granted, and then says further to confirm that Mr. Mancini had no obligation to rebut anything because Villa Bellini had failed to show that he was not a shareholder. So rather than putting the burden of proof on the civil plaintiff where it ordinarily falls to demonstrate that he in fact is a shareholder of the company, the court accepted the unproven allegations of the petition, relieved Mr. Mancini of proving any of those, shifted the burden to Villa Bellini to actually disprove those, and then further changed the burden from the standard preponderance to the good cause that accompanies a mandamus proceeding. So for all of those reasons, Villa Bellini would suggest that the trial court's final judgment of mandamus must be reversed. The trial court also refused to dismiss the mandamus proceeding for Mr. Mancini's failure to state a claim. One of the elements of petition for writ of mandamus must include is pleading and then subsequently proof that there is no alternative remedy. And here, there's no allegation of that in the mandamus proceeding. Villa Bellini moved to dismiss on that ground and also raised the ground again in its response where it asked for denial.
Well, this ties in a little bit to that argument, which is that utilizing mandamus in this corporate shareholder dispute seems to me an odd fit for mandamus, but mandamus is itself kind of a little bit of an odd duck. I see where your friend on the other side has cited a couple of cases where a couple of DCAs have indeed done this. It's been a while, but have indeed done this in the past. To your knowledge, has this district ever embraced or adopted the notion that, yes, utilizing mandamus in a corporate shareholder dispute about records is appropriate qua mandamus. Like, you could, it even fits within mandamus, putting aside whether or not there's a factual dispute.
I am not aware that it has. I mean, and I looked to try to find some explanation for how a private corporate dispute could become subject to, I mean, and it just seems some arcane remnant. You know, I don't know if it's because corporations at some time, had the imprimatur of the state, and
Back
so
in the
therefore,
day, yeah, you
right,
actually had to get an act from the legislature to enact your corporate, maybe.
right. But your point is well taken in that it seems to make no sense. If mandamus is designed to compel a public official to perform a ministerial act, how in the world do you get into the mandamus arena to try to resolve a dispute about whether someone really is a shareholder of a private corporation? And I think that what you see more of now in what should have happened in this case is the trial court should have denied the petition, and said, I think there are disputed issues of fact. Mr. Mancini then could have asked for leave to amend or to refile and could have asserted a declaratory judgment action, and that could have gone forward with the appropriate burdens, resting where they would typically be. And that could be decided. And in fact, you'll see one of the cases that I cited from one of the foreign jurisdictions says that's exactly what ought to happen. If there is a dispute of fact about it, you have to go try that somewhere else and then come back if you still can't get the records once you've been determined to be a shareholder. So again, I think in addition to the fact that the petition should have been denied because there were disputed issues of fact, the trial court from the very outset should have dismissed the petition because Mr. Mancini clearly has an alternative remedy, the ones that we discussed. He even says on page, I think it's 28 of the answer brief, he concedes that he did have an alternative remedy in the form of a direct action under the statute, and in fact goes so far as to suggest that he actually prevailed under that alternative claim and that the court ought to affirm on that basis. Of course, that takes us back around to the fundamental problem here, which is that the court actually proceeded as if this were a mandamus proceeding and then shifted the burden of proof. I'd just like to mention in closing that Mr. Mancini has filed a request for appellate attorney's fees in this case. This is an interesting statute. It's not a pure prevailing party statute. A prevailing shareholder is not entitled to an award of attorney's fees if the corporation can demonstrate that it refused the inspection of its records because it had a reasonable doubt about the right to that inspection. And here, I think it's really beyond dispute that Villa Bellini established reasonable doubt. It took a 2-day evidentiary hearing to resolve that doubt, and so for that reason, we would ask that the motion for fees be denied. And I'll reserve the rest of my time.
Thank you.
Your Honors, may it please the Court, I'm Brandon Vesley from the Florida Appellate Firm. I'm here with trial counsel Rob Eckert and my client Ciro Mancini. Your Honors, counsel's view of the evidence, view of the law is unique and different from what everything I've read in this case. Every case that she's cited, there's no question that the issue in this case is whether my client was a shareholder, and that issue is presented to the court, and the court has to make a determination that he has the clear legal right as a shareholder to the documents in question. That determination is by evidentiary hearing. The Radford versus Brock case out of this court lays the groundwork for what has to happen in a mandamus case like this. The first thing the court has to do is look at the petition. Does the petition clearly state that he's entitled to relief?
Well, let's start with that proposition.
Sure.
Has this district ever embraced mandamus as appropriate relief for a private corporate dispute about records?
I have not found a case in which this second DCA has made that analysis or determination. However, it's well ingrained in Florida case law. It's well ingrained in national case law. There's many cases that have been cited both by counsel and myself, where this has actually been the remedy that people have sought in order to get documents like this. There's a clear legal right.
Can you see why this might bump up against some other area of the law which talks about in mandamus? Typically, mandamus is reserved for compelling a government or an officer of the state to comply with a ministerial duty. And you can kind of understand why mandamus might still have some wherewithal in that unique context, because it does afford. I mean, my goodness, you get a trial right out of the box. You get to do it in a show cause context. So instead of having plaintiff presents their case first, defendant cross-examines and then puts on their case, you get the return hearing, however quickly you get it. You can see why there seems to be some incongruence here that I'm having a hard time working through.
Your Honor, I recognize that a lot of times, most times, it is a governmental entity
Right.
for which mandamus is sought. However, there's nothing that says it has to be. And in this particular instance, this is the perfect scenario for a mandamus, because what he's seeking is basic shareholder rights, basic rights that any person that has one share of stock in any corporation can obtain these documents. And he's doing it because he has no other alternative to get the records, so he can determine what his rights are. The same documents that they're...
That's not true. I mean, you can bring a deck action and you serve discovery.
Your Honor, he needed to see the documents that they're relying on to say he's not a shareholder before he even brought any type of an action.
Well, no, you can bring a deck action when you are uncertain about your rights. That's
Well,
the point. That's the point of a deck action.
What we did in this instance, Your Honor, is we brought the mandamus petition, but we also sought by motion the documents directly under the statute, and the court granted them in both instances. So if there's an issue of whether we did that correctly or not, there's a tipsy coachman argument there.
But it's not really tipsy coachman, because the only way that the court grants that motion is by virtue of having previously made the factual determination that,
Which came about through this return proceeding in mandamus.
Your Honor,
they're not really alternative findings. They're inextricably linked,
well,
right?
they didn't raise the issue of alternative remedies as an argument on appeal until appeal. They never raised it below. We proceeded through all the discovery in this, all of the proceedings in this case, including the 2-day trial where all the evidence was presented, and that was never raised as an issue once. And I know that
Wait, what wasn't raised as an issue?
that we had alternative remedies as a.
Well, they did argue in the motion to dismiss that mandamus isn't appropriate in this case. It should be denied. You all in your memorandum in response to that joined to that issue, argued no, mandamus is appropriate in this context.
But not on the basis of alternative remedies, Your Honor. It was argued based on the fact that they believed that they had a legal dispute, and we wanted to inform the court that the legal dispute in this case is not a legal dispute. It's a theory on their side. On our side, on the appellee's side, the petitioner's side, the argument was that he is a shareholder. There's nothing that says he's not a shareholder. They came and did some kind of after-the-fact accounting and determined that on their own, without any evidence, that he's not a shareholder, and all of a sudden now they're trying to negate 2 years' worth of documentation that says he is a shareholder.
When you say there's no evidence, there was testimony, right?
The testimony only is that he didn't pay for his shares. That doesn't mean that they acknowledged that he was a shareholder for 2 years. This man founded the company.
I get it. I get all that. I read it.
That goes to, doesn't that just go to that there was, there's a disputed fact, but we think we had really good facts on our side. They didn't have many facts, but it's a dispute. You've got testimony that's saying, no, he didn't pay for his shares, he's not a shareholder.
Your Honor, as Judge Duraka found, that doesn't create a substantial issue of doubt. They have to, let me read a case to you. This is from the Gorvinta case that they cited. It says, the mere assertion of ownership of stock would not entitle the claimant to the writ, and the mere denial of ownership of stock is not sufficient to deny the writ, Because if the mere denial were sufficient, such a writ could not be had in any case. And if a mere assertion of ownership of stock were sufficient, the writ would be issued in every case. That's why an evidentiary hearing is needed to flesh out whether the petitioner has a clear legal right to the performance of whether there is, to performance, and whether there's a substantial doubt about that right. So in this particular case, Your Honor, the court had that evidentiary hearing. It looked at all of the evidence and said there's a mountain of evidence on one side, essentially a theory on the other side, and there is a clear legal right. He's entitled to the documents. We're not talking about, the special formula for Coca-Cola. We're talking about documents that any shareholder can obtain when they have one share of stock in a corporation. And on top of that, just to be careful, because obviously they didn't want to turn him over, he imposed a confidentiality provision on the documents. So there were safeguards there as well. So I don't see where Judge DeRocca did anything other than what the precedent in this state allows him to do, and whether we did anything that we were not permitted to do under the precedent of this state and all the states across the country.
What about the argument of the improper burden shifting?
Your Honor, the burden is we present a petition that says we're entitled to documents based on shareholder status. The burden then shifts to them to show cause why we're not entitled to the documents. The evidentiary hearing comes when they say, well, we don't agree. If they said he was entitled to them, the case is over. If he says we don't agree that he's entitled to them because he's not a shareholder, the court has to have an evidentiary hearing. They have to then show cause of the evidentiary hearing as to why, he is not a shareholder.
But the proof was on them to show that he wasn't.
To show substantial doubt, and they did not prove substantial doubt. There's not as if they show substantial doubt, the case, the Garvinta case that I just read from, says if there's substantial doubt, then you have to stand down. The court can't go forward. But if there's no substantial doubt, if there is a reasonable dispute, they raise, and if there's a reasonable dispute and substantial doubt, then the court cannot go forward.
Which is it? Reasonable? Because I hear those two terms and I think different levels of dispute. Reasonable dispute or substantial doubt. I don't see those as being co-equal. Do you?
These are buzz terms that came out of the cases that they cited in their brief. They were not debatable.
I am certain that whatever they are, that the courts that wrote those opinions did not mean them just to be buzzwords. I'm certain that they meant them to be applicable standards.
When I'm reciting them, I'm reciting them as my buzzwords that I pulled out of those cases to say.
Well, what do they mean? What do the buzzwords mean?
Well, one is not debatable. Is it debatable that he's a shareholder? We say he's not. We say that we proved to Judge DeRocca that he is a shareholder, and there's no debate about it. All of the documentation, everything that we had for 2 years, demonstrated his shareholder status, and now they come in after they fired him and say, no, he's not a shareholder anymore because we think he didn't pay for his shares. And that's not sufficient for documents. If you're trying to get something else, maybe it might be, but it's not for the determination of whether he's entitled to the documents that they're relying on to say he's not a shareholder. Whether it is free from substantial doubt. The question Judge DeRocca would have.
But here's the thing. In that argument, what you're trying to do, and I get it, you're trying to say, look, this is just for purposes of the statute that we're seeking here. But really and truly, for purposes of res judicata, what you've done is effectively established him as a shareholder for all purposes, not just for the purposes. Because, listen, if there's any dispute about corporate governance going forward, this decision is the first thing you bring up. Hey, Judge, we've already plowed this ground. Court's held he's entitled to records because he's a shareholder. Done.
That's correct.
Right. So perhaps all the more reason why mandamus is kind of an odd fit here, because it's not just for purposes of getting the documents, although that was really what you were seeking in this mandamus proceeding, but because of what issues here, you get a judgment that says he's a shareholder.
Your Honor, the respondent appellant never refuted he was a never disagreed with the concept that they recognized he was a shareholder for 2 years. They only say he's not a shareholder now because their accounting goes back and they say, oh, well, he didn't pay for he didn't give us the money he was entitled to. There's not even a document that says he has to pay for shares.
But
There's a document that says what the shareholders have to contribute.
But aren't they complaining that he wasn't a shareholder at all, even during those times that he was listed with the state and the corporations?
They're saying that now. This is an after the fact concoction of a theory to prevent him from having the very documents that they're claiming say he's not a shareholder.
This was the factual scenario before the petition for writ of mandamus was filed. This isn't something that was concocted after the lawsuit began. This is something where this legal dispute as to the entitlement to the very core of what he's getting at happened before the lawsuit.
When he demanded the records is when they came with, that was before the petition, obviously, because you need to set the groundwork. So he asked for the records under the statute, and they said, you're not a shareholder. And then his response was, why? I have proven for 2 years you have documentation, you've acknowledged it, and they never say that that's not the case. They're saying, oh, but after we thought about it some more, after we went back and reviewed everything, and these are the records you want, but we're going to say, our review of the records say that you're not entitled to them. Our review of the records say you're not a shareholder. So what we're talking about, Your Honors, is not look, if there was a genuine dispute, if there was a debatable issue, if this was anything like that, Judge Urraca would have needed to walk away and say, this is not for me today. But because there's no evidence to truly refute this, to say that he's not a shareholder, because there's not even a document that says, in order to be a shareholder, you need to pay this money. There's nothing like that. There's a document that they cited from an earlier version of Villa Bellini, where each person was 25% owner, each person had to put in $60,000. It didn't say, in order to get your shares, you got to put in $60,000. It was just, and that was the only document that they put in. In response, we put in a mountain of evidence that says that all along they recognized him as a shareholder. This person has been a shareholder, a founder, head chef, manager, putting in his own money all along, and to say he's not a shareholder is just, it's nonsense. I think it's unfair to Mr. Mancini to say that because the court doesn't necessarily recognize mandamus as something that should be brought in a private context as opposed to a governmental context, a public context, that he should lose today when there's plenty of precedent out there for this exact type of scenario. I cited the court to the cases. They've cited the court, the opposing counsel cited the court to the cases. The Garaventa case is one of them. The Moore case is another, where they were seeking documents. So it would seem very unfair to disregard the precedent at this time and say that that he can't do that he wasn't permitted to do exactly what he did in this case and file a petition for writ of mandamus. Also, I think, Your Honors, when opposing counsel, appellate counsel wasn't the trial counsel, but when the trial counsel for the respondent had the case in trial, that's when you bring up the issue that there will be alternative remedies. Now, the alternative remedies that you mentioned, Your Honor, a deck action under the statute, whether he's a shareholder, that's possible, but that's not something that was pursued, and it wasn't something that was argued to the court below. The court had before it the issues. You'd be creating an issue out of, that's been waived on their side. They bring it up for the first time on appeal. When I brought it up in my brief that it wasn't preserved, in their reply brief, they cited 2 spots in the entire record. Both of those were where they just mentioned, it was the Huffman case that they cited to, and I'll give you the page number if you want to look at it, pages 185 and 397. And the only thing that those pages say about alternative remedies is just happens to be the quote from Huffman that is something that needs to be addressed. They don't go into detail. They don't argue it substantively that we didn't bring up alternative remedies. So there's really not that issue before the trial court. So this court will be injecting that issue for the first time. It's been waived, Your Honor, not preserved. And if you look at their response to the petition for writ of mandamus, they actually had two responses. One's on page 387 to 394, and the other one's on page 395 to 405. If you look at both of those, that issue is not raised at all. And if you go through the trial transcript, the entire trial transcript, the word remedy comes up one time, and it has nothing to do with alternative remedies. And that word was uttered by trial counsel Mr. Eckert, not them. So you are injecting an issue that was not there, and frankly, it's been waived. It's not preserved. So back to what Judge Juratka found. These are the findings that he made when he was considering whether there was a clear legal right. That's the issue before him at the evidentiary hearing, whether there was a clear legal right. And in his oral pronouncement of his ruling, he actually has a written judgment and an oral pronouncement. He said, so central to the question we have today is whether Mr. Mancini is a shareholder of Villa Bellini Restaurant Lounge. Based on the evidence, which includes exhibits based on the testimony, I reached the conclusion that Ciro Mancini is a shareholder of Villa Bellini Restaurant Lounge. It is clear to me that share certificates should have been issued to the shareholders, including but not limited to Ciro Mancini. All I have in front of me to decide is, in order to get to the documentation, was whether Mr. Mancini is a shareholder. And I've decided that. Based on the evidence in front of me today, last week, and the testimony, I find Mr. Mancini is a 25% shareholder. That was from his oral pronouncement of his ruling. In his final order, he wrote, respondents were issued an order to show cause in this matter and have failed to demonstrate good cause for the petitioner's writ of mandamus and motion for summary relief not to issue. Petitioner, based on the evidence and law presented, need not rebut that Mancini is not a shareholder, since it has been demonstrated to the satisfaction and conscience of the court that he is and always has been a shareholder of Villa Bellini Restaurant. The shareholders in Villa Bellini are and always were, during the operative period, Ciro Mancini, and then he goes on to state the other gentleman. So there was no evidence to rebut that. And so the issue now for this court is to determine whether he erred, and it's an abuse of discretion standard based on the plethora of evidence that was presented on behalf of Mr. Mancini and the lack of evidence, other than their testimony saying he's not because he didn't pay for it, when there's no documentation that said he had to pay for it. There's no evidence on their side. Abuse of discretion. Would a reasonable judge make that determination? The findings of fact, competence.
You need to wrap it up now.
Findings of fact were competent substantial evidence test, Your Honors. So based on the standard of review that this court is bound to follow, without creating new law here, without saying that you're not entitled to bring a mandamus for this, then Your Honors, you need to affirm based on the abuse of discretion standard. Thank you for your time.
A few points in rebuttal, please. I may have misheard, but I think the appellee conceded the argument that a factual dispute requires the denial of a petition for writ of mandamus. I think he now just takes issue with whether or not the dispute was significantly substantial, that we didn't really do a good enough job of identifying evidence in support of the fact dispute. But of course,
I think your latter point may be an accurate representation of the argument. I didn't hear a concession.
Okay. Then maybe I'm overstating. But I think he said that in some cases a fact dispute could preclude the mandamus petition being granted, but maybe not in this one but then reverted to the substantiality of the evidence and not just the fact that there is in fact a fact dispute.
Did you all raise to the trial court the argument that, look, there's a deck action, there's injunctive relief, there's a statutory action, and where would I go it's not in the motion to dismiss, but where would I go in the record to find that?
So in the motion to dismiss and in the response to the alternative writ, essentially we articulated the elements and argued that he had not met the elements, one of which was to establish that there is no alternative remedy. And then in the response to the motion to dismiss, Mr. Mancini argued that the lack of another remedy is in fact not a pleading requirement at all, and said, quote, notwithstanding respondent's assertion to the contrary. And that's at page 203 to 204 of the record. So in essence, we said you have to plead and prove that there's an alternative remedy, and he said, no, we don't, even though you've said we do. So, was there a lengthy discussion of it? No, there wasn't. But
I didn't see it mentioned. I mean, that's why I'm bringing it up.
No, it was, and I will, in the response to in the motion to dismiss and in the verified response, at pages 185 and 397. So, counsel for Mr. Mancini also argued that part of the problem here is that he needed the documents that the corporation had in order to establish his rights to inspect the documents, and that it is a circular, what would we have had him do? But I think it's interesting, if you look at his argument, what he says is that, and this is in the trial as well, is that part of the evidence that established that he paid for the shares that he offered was a $15,000 check, a $25,000 wire transfer, and he said he also incurred numerous startup expenses on his credit cards. All of those records are his. They're not the corporation's records. Be records in his checkbook, he would have the wire transfer receipts, and he would have his credit card receipts. He produced none of that. Counsel for Mr. Mancini also said that he believes that at least I believe I heard him say that he believes that the mandamus proceeding would be sufficient and would be permissible to determine fact disputes that underlie a request for documents, corporate records, even though it might not be permissible for the determination of other fact disputes. And of course, we know that's not all the trial court did here. As Judge Lucas pointed out, the court has determined that Mr. Mancini is a shareholder for all purposes. It's ordered the company to amend its tax returns to reflect that and to make any distributions to Mr. Mancini that would bring him, to true up any distributions that made during the period of time that it didn't treat him as a shareholder, and to do so on a go-forward basis. I wanted to clarify one thing that Judge Smith asked about whether or not this issue arose before the lawsuit was filed or not. I think the issue came to a head, and this is on page 11 of Mr. Mancini's answer brief. He says on March 20th, 2017, Villa Bellini sent Mancini a revised balance sheet that showed that he owned no stock. Shortly thereafter, on April 7th, 2017, he sent the statutory demand to look at the records. So in fact, the issue did come to light before the lawsuit was commenced. Finally, I think I'd like to direct the court's attention to the Emmer case. I think that one is... Okay. If you just take a look at that, I think in that case, the court denied a petition for writ of mandamus because it found it would have to decide the ownership of property before it could go further. So I thank you.
Thank you all. All right, well, it's a little bit past 11 o'clock, so I think we're good to start our 11 o'clock docket if we have everybody here for that case. And we'll just go ahead and press through and finish up.